Okay, if you are prepping for an international trade law exam, you are going to want to pay close attention. The 1952 Belgian family allowances case is one of those foundational GATT disputes you just have to know. It really gets to the heart of the clash between a country's own domestic social policies and the rules of international trade. So let's break down exactly what happened and why it's still so important today.
So, at its core, this whole case boils down to one huge question. Let's say your country, like Belgium, has a really strong social welfare system, and you fund it by taxing your local industries. What happens when you import goods from countries that don't have those same costs? Is that an unfair advantage? Well, Belgium sure thought so, and their solution put them on a direct collision course with Denmark and Norway, which forced the GATT panel to get involved.
To really get a grip on the panel's final decision, we're going to follow their exact train of thought. We'll kick things off with the controversial tax itself, then walk through the key legal questions about discrimination, take a look at Belgium's pretty clever defense, and then finally see how the panel pieced it all together for their landmark verdict.
All right, Section 1, let's dig in. At the absolute center of this whole dispute is a Belgian law. Now, it was designed to protect their domestic social policy, but in doing that, it created a massive problem for international trade. Let's look at the specific wording that caused all the trouble.
I know, this legal text looks super dense, but the idea behind it is actually pretty simple. What Belgium is doing here is creating a condition. They're saying, look, if a country's businesses aren't required to pay into a family allowance system like ours, then their products are going to face a special charge when they're sold to our government. It's a law that directly takes aim at the social policies of its trading partners.
So, here's the bottom line. If a Belgian public authority, like a government agency or even a local town council, bought a product from a company in, say, Denmark, it would tack on a 7.5% charge to that purchase. And why? Well, it was because Denmark didn't have the same kind of employer-funded family benefits that Belgium did. The whole idea was to level the playing field for Belgian companies who did have to pay into this system.
Now, this brings us to the first major legal hurdle. And for your exam, this is a really critical distinction to understand. The panel had to figure out what kind of charge was this, legally speaking, because the answer to that question determines which GATT article applies, and that sets the entire course for the rest of the case.
You see, the GATT essentially has two different buckets for charges like this. Was it an import charge under Article 2, something collected right at the border? Or was it an internal charge under Article 3, something that gets applied after the product is already inside the country? This really matters because Article 3 has much tougher rules against discrimination. So the big question for the panel was, which bucket does this 7.5% levy fall into?
The panel's logic here was pretty straightforward. This charge wasn't being collected by customs agents when the goods crossed the border into Belgium. Nope. It was applied later, at the moment a government body actually paid for the stuff. And because of that, it was an internal charge, which meant it had to follow the rules of GATT Article 3, and by extension, Article 1.
Okay, so the panel says it's an internal charge. That means we have to look at it through the lens of the non-discrimination rules. The next logical question then becomes, was this charge discriminatory? This is really the heart of the complaint from Denmark and Norway.
And here is the problem, laid out in black and white. Belgium had basically created two different classes of trading partners. You had one group, with countries like France and the UK, that was totally exempt from the charge. And then you had another group, including Denmark and Norway, that got hit with the tax. This is, by definition, differential treatment. You're treating identical products from different countries differently, and that is a massive red flag under the GATT rules.
This kind of favoritism runs smack into one of the absolute pillars of the entire GATT system, the Most Favored Nation principle, or MFN, found in Article 1. And the rule is simple. You can't play favorites. If you give an advantage to one country, like, say, an exemption from a tax, you have to give that exact same advantage to all other GATT members, and it has to be immediate and without any conditions. Belgium was clearly not doing that.
So, case closed, right? Seems pretty obvious. Well, not so fast. Belgium had a very clever defense up its sleeve, and it was one that relied on the history of the GATT itself.
This right here was Belgium's ace in the hole, or so they hoped. See, when countries first signed on to the GATT, there was this thing called the Protocol of Provisional Application, which created a special exception. It essentially grandfathered in any mandatory laws that were already on the books before the GATT came along. So Belgium's argument was simple. Our family allowance law is from 1939, a full 8 years before the GATT even existed. Therefore, it's existing legislation and it should be exempt from these new MFN rules.
That was a pretty strong argument, you have to admit. But the panel wasn't just going to take their word for it.
They decided to put this existing legislation defense under a microscope to see if it really held up.
So the panel pulled out a test that had been established in an earlier case. For an old law to get this special protection under the protocol, it couldn't just exist. It had to be mandatory. And what that means is the government had absolutely no choice or discretion in how it was applied. The law had to completely tie the government's hands. The big question was Belgium's law truly mandatory?
And this is how the panel just completely dismantled Belgium's defense, piece by piece. First, they agreed, yeah, on the surface the law looks mandatory, but then they dropped the bombshell. They pointed out that Belgium had already given exemptions to countries like the UK, even though their social systems didn't perfectly match the criteria in the Belgian law. And here's the kicker. Those exemptions were granted by executive action. That was the smoking gun. If the government had the power and discretion to grant an exemption, then the law, by definition, could not be mandatory. And just like that, Belgium's entire defense crumbled.
So, with Belgium's main argument completely taken apart, the panel was finally ready to deliver its verdict and its recommendation.
The finding couldn't have been clearer. By discriminating between its trading partners, the Belgian levy was inconsistent with the most favored nation obligation in Article 1. It was a direct violation of one of the GATT's most fundamental principles.
But the panel went even further than that. They didn't just point out the technical rule breaking, they made a broader statement about the very nature of this law. They said the whole concept of one country judging another country's social system and then slapping a tax on them based on that judgment, well, that was hard to reconcile with the cooperative spirit of the GATT. It was a really powerful statement about what the trade agreement was fundamentally all about.
And so the final recommendation was totally straightforward. The panel urged Belgium to move quickly to get rid of this discriminatory practice, either by changing the law or through some other means, and to bring its system back into line with its international obligations. So as you can see, this case is about way more than just a 7.5% tax. It established a vital principle that gets tested all the time, even today. Where do we draw the line between a country's right to set its own policies and its obligations under international trade law? The panel's answer back in 1952 was crystal clear. You cannot use domestic policies as a backdoor to discriminate against your trading partners. So for your exam, remember this case as the foundational lesson on the power of the non-discrimination principle and the very narrow limits of that existing legislation defense.